that we can have a similar outcome. And if they do it beforehand, I'll come off document.
I want to do it, and hopefully they see that you're really willing to, so, all right. So I just want to say hello, that's it.
So, sir.
All right, thank you, Brady, we'll see you there.
Why, sir?
So you were in February charged with terroristic threat of a family or a household member. It's come to my attention that you have now picked up a violation of a bond condition or a protective order. I have no idea what happened, but I want to find out. I have the right to remain silent. Anything you say can and will be used against you. I want you to know that you're not here alone. I have a lawyer for you here. He's right there, so you know that you're not here alone, okay? Okay, so...
Okay, big moment here. Miranda rights read out loud. That's the classic, anything you say can and will be used against you line. But did you catch the judge reassuring him that a lawyer is present? That means the court is making sure his rights are fully intact. But also, things are about to get serious.
Remain silent. Exercise that.
On March 29, 2025, law enforcement officers were on patrol when they observed a white Honda Accord driving south on a public city street located in Harris County. The law enforcement officer ran the vehicle's license plate through NTIC and observed the vehicle's registration had been expired since June 2023. Law enforcement officers initiated a traffic stop and activated their emergency equipment and followed the defendant's vehicle that drove into a gas station parking lot and pulled over to stop. The law enforcement officer approached the defendant's vehicle and observed the passenger sitting in the front seat wearing a seatbelt. The defendant requested the full name and birth of the passenger, who identified herself as Stephanie Avalar, and that was confirmed by the law enforcement officer. The law enforcement officer also found that her name came back as a protected person from a recent violence incident and ran the identifying information.
Boom. Probable cause confirmed. The judge just made it official. They're moving forward. Now, here's a question for you. Should violating a protective order automatically void your bond, or should the court consider the context? Let me know in the comments.
They came back under the same protective order as the defendant for that case as well. The law enforcement officers reapproached the vehicle and detained the defendant and confirmed that the bond, one of the bond conditions and the protective order points the defendant shall have no contact with the
So it's just the right virtue of the, so we issued the no contact, right?
Yes, Judge.
All right, so Mr. Avalar, I'm going to find that there's sufficient probable cause to go forward. You have to understand that when we have court orders, we mean it. It's not hard. You have a lawyer. When you want something changed, you talk to the lawyer can come to us, and we hear things out, and we can change things. But when you try to do stuff on your own, everything goes sideways, and it goes sideways quick, as you now know. So,
in Your Honor, we will be, we'd like to approach off docket tomorrow to try to have the MOAP amended. The CW, but they have not been able to speak with her to clarify that she would in fact like him to be able to come home and have contact and the like.
So what happened?
He appeared in peace court on February 13th. He received a PR bond, and last week he came in here for arraignment. He got reset for April 23rd.
Right, but I'm showing now he's bond active after the new books. Why? Did they give him another PR bond?
No, this case was never...
Look, it shows bond made on the terroristic threat.
That's from the previous PR bond. He was never revoked after since the case. This case is still been on bond.
Did they not address it? And I'm...
That right there is why this judge isn't playing around. He's basically saying, fool me once. And honestly, it's wild how often defendants try to handle legal issues on their own without talking to their attorney. That's like performing surgery on yourself with a butter knife.
I'm at a loss if they never addressed it.
Yes.
It was new court. His only reset is for April 23rd.
Mr. Woodward, my concern is that, they gave him a PR bond on the terroristic threat. I don't even sure that the PR bond was given. Oh, here we go, on 2/13, and now he's picked up a violation of protective order. So I can't continue to give you a PR bond when you're picking up new cases, man.
That's not speaking. Could I ask? It's because I made bond.
No.
Sorry.
You need to talk to your lawyer when you're talking, because I don't want you to say something that hurts your case, Sir. I'll give you time to talk to him, but, I can't, You know, we do things a certain way. You can't do stuff on your own. You've been through the system long enough to know that, you know?
Yes, sir.
Are you on parole at this time?
I'll say I'm not on parole, but I paid for my bond.
Hold on. So, no PR bond and a terroristic threat. Okay? Let's do this. Your lawyer said he can be here tomorrow. So we'll have him come here tomorrow so he can talk to you and you guys can read through, try to figure something out. So, Mr. Woodward, you say you can be here tomorrow?
Absolutely.
You want to address it, I guess, then?
Yes.
We'll try to figure something out.
Judge, you're supposed to get people released today because it's sure on the VPO.
I'm not giving him another PR bond when we picked up a VPO though.
Do you want me to revoke
The
the
PR bond. Yeah.
No, Your Honor,
Yeah.
I certainly understand how you work, but since I'm not there with my client, I just like for him to experience that. The facts of the underlying case, Your Honor, are that, you know, he and the CW, they're in a relationship. You know, they had an argument. She grabbed his hair first, was pulling him, then he was grabbing her, but a text message was sent from an unknown number saying, if you don't come home, I'm gonna fuck you up. Excuse my English, Your Honor, but that's what was the crux of the PC, Your Honor. For the terroristic threat case.
I don't know. I guess what happened in the terroristic threat?
Yes, Your Honor, if I just have a moment.
My understanding is that the CW is willing to communicate misunderstanding of the facts. I believe the state called her once. She said she wasn't available, but, you know, she would be if they called back. I don't think that, you know, she's been able to communicate that there was a little bit of a misunderstanding of the facts.
Your Honor, what I have is that this was from...
That text message evidence is damning. The court's now connecting the dots. Defendant admits there was an altercation, and the threatening messages line up with what the victim said. This is textbook corroboration. Drama aside, this is what prosecutors live for.
The threat was made during an altercation where the defendant told the complaining witness, and I quote here, I apologize for the language.
Don't be shy. Come on. We all know the F word.
I'm going to fuck you up if you don't come home.
I understand that could be made during an altercation, Your
If you
Honor.
don't come home. It was made during, defendant admitted that there was an altercation, admitted that he told the complaining witness, I'm going to fuck you up if you don't come home.
Your Honor, I'm looking right at the summary of facts. It literally says, on her cell phone contacts, complainant stated the defendant then began to threaten her via cell phone text, which he stated, I'm gonna go kick your door, I got you, I'm gonna fucking kill you. Complainant stated she was filming from an unknown number.
Your Honor, it is further down in the summary of facts that there is an admission.
I mean, of course, it's the word where someone can make something from an unknown number, but they can corroborate it at the same time, you know? And I think that that's what the state is saying here, that he corroborates the actual text message saying that I'm gonna go fuck you up, right?
Yes, sir.
Yes.
The problem is that we have him, he's still doing stuff on his own, you know? I've told him not to do it, admonished him not to do it, and he's still, you know?
Yes, sir.
In this life, when you do things the right way, good things happen. When you do stuff the way you want to do it, in violation of orders, and you've been through this sufficient that you know? No, it's not the end of the world, but how do I get your attention so that you realize that we mean business? If I just give you...
Yes, sir. I paid out of my pocket to get bonded. They gave me a bond downstairs and I paid for it.
On your VPO, but I'm not going to give you a PR bond when you're picking up the VPO.
She called me, her home had it.
No. Like I said, talk to your lawyer first. Before we start telling them stuff, because I don't want you to put yourself in your mouth when you think you're trying to help regardless. Now look, we can come back tomorrow. He's going to come here. We can try to work something out. But
I was just trying to help, sir. I've been staying away from her. I got like 10 days left.
Sir, I got you. I'll come check up on you, okay?
back tomorrow, we'll deal with it and we'll figure something out. So you will definitely be here tomorrow, Mr. Woodward?
Absolutely, Your Honor.
Okay, so I'm gonna revoke it for now. Come back tomorrow, we'll talk. Do you have a place so they can reach out to the complaining witness so they can get a rip done by tomorrow, Mr. Woodward?
I do not have it readily available, Your Honor. I can likely get
Okay,
it.
so can you try to do a rip between now and tomorrow so we can go forward? Good morning, Mr. Sullivan. So you were charged with assault on a family member, making up to a year in jail and or a $4,000 fine. We were going to do probable cause. You had the right to remain silent. Anything you say can and will be used against you. For the right to have an attorney present, if you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, at approximately 15:39 hours, the law enforcement officer was dispatched to an address in Harris County, Texas, in reference to a disturbance. The law enforcement officer arrived on scene, witness who stated that her husband, the defendant, had been arguing because her adult daughter does not like the defendant and asked the witness to pick between having a relationship with her and her grandchildren or the defendant. The plaintiff stated she decided to sever a relationship with her daughter and informed the defendant of the defendant, and he began arguing with her. She then expressed that she hated him, and this made the defendant more upset, and he told her to hit him if she hated him so much. The plaintiff stated she hit her children with a closed fist on the head and face area 3 times before losing balance.
Hold up, did anyone else catch that? She hits him 3 times, then he retaliates and pins her down. This case is a legal tightrope. Was it mutual combat, self-defense, or straight-up assault? Drop your take below, because this one's murky.
Slipping and falling. This fall caused her to hit her face on their bedroom dresser. The plaintiff then said she got up and crawled into bed, and she was lying on the furthest corner of the bed closest to the wall and covered her body with a blanket. The plaintiff said that approximately 10 minutes went by, and Mr. Sullivan, the defendant, continued to argue with her. He crawled in bed, grabbed her, flipped her over, put her backwards on the mattress, and used his body weight and then on top of her while placing both hands on her upper arms to hold her down. The plaintiff said this caused her pain, and she was able to free one of her arms and use her hand to grab the defendant's genital area and making him let go of her completely. The defendant then used his right hand. The clue was added, the fight then diminished, and is that the law enforcement officer observed visible injuries, including large bruises on both arms and injuries to the top and bottom inner glove.
Blaze, are you hearing this?
Yes, Your Honor.
Interesting. So she's the initial aggressor, though, correct?
Your Honor.
So it looks like he says, hey, hit me, antagonizing. She gets into it. She pops him, what, 3 times in the mouth, you say?
Yes, Your Honor.
No, don't say anything. Sorry.
Your Honor, the only thing I would ask is, this is not home court's case, if we can just stand down, wait for the DVD prosecutor to be here. I don't know if he's spoken to the point yet, if he has anything more to add. I would just ask the court to withhold the finding until we can get the prosecutor to go.
All right, Mr. Sullivan, let me get, I'm going to also appoint him a lawyer, if you don't mind. I'm going to appoint him someone as well, so we can do just.
That's fully fine, Your Honor. Let me, and I'll email DVDs.
Okay. All right, thank you. Okay, just take a seat real quick, all right?
All right, Judge, next.
I'd like to do some additional research as well before I find probable cause in this case. So what I'll do is I'll put this case on for Wednesday for a formal probable cause hearing. In the interim, Mr. Sullivan, I'm ordering you not to have any contact with this person whatsoever. You understand?
Yes, sir.
I don't care what's going on in your life.
I got you.
For the moment, I'm gonna, I don't want you to have any contact. I don't want you to go where this person lives, where this person works. If I find that you do, I will revoke them and put you in jail.
Yes, sir.
We'll come back in 2 days. I would like to do some further research on it because, I really like to look at every case, do a deep dive to ensure that there's probable cause before we go forward. So, I don't blindly find PC for anyone. I'd like to do things in the fair way, but at the same time, I want to ensure that my county and every person in it is going to create bond conditions to this effect. They're probably going to reach out to her between now and Wednesday, and if they find that you're trying to communicate with her, it's not going to go well. Do you understand?
Yes, sir.
Do you mind filing no contact in the weapons, please?
Yes, Your Honor. No contact, I'm sorry.
No weapons.
No weapons, Your Honor. Thank you.
One of the things that they teach us is, never make rash decisions because it may be the wrong decision, and that's why I'd rather take a little bit of time before we do something to ensure that what we're doing is the right thing to do. So we'll put it on for Wednesday, come back Wednesday, and then we'll have a decision for you.
Thank you, Your Honor. Appreciate it.
I've given you a lawyer, so just stay in touch with Mr. D, and then we'll come back, and then we'll find you.
Thank you, Judge.
Hey, so Carl's here. Gomez?
Yes.
Was dismissed.
Yes.
Both cases. Both cases were dismissed, or it's just one?
Both of them. He pled to deferred on the felony case, and the state filed motion to dismiss the
Okay.
underlying.
And then Ponce was the other one. I don't know.
Ponce was no PC previously, but it has not been presented to the grand jury yet. I don't know if the state plans on doing so or not. April 28th?
Yeah.
Okay, thank you.
All right. Sir, do you have a lawyer today?
I do, she is not supposed to be present, so.
Who, did you hire the person?
Yes, I hired a lawyer, so.
It's okay.
I can spell out the name if you want me to. Yes.
They haven't filed any documents yet indicating, do you see on the bottom of page 12, if they filed any documents for representation?
What was the case was on, Gaston or?
No, bottom,
Okay.
yeah, well, bottom was,
No judge, nothing.
they have not filed any documents indicating that they're, okay, you can go outside and go call them.
This might sound minor, but bond conditions like don't drive without insurance are real legal landmines. Mess it up, and boom, jail. It's not just about the big charges, it's the small stuff that trips people up.